Hello, everyone, and welcome back to another episode of our podcast, Decoding with Finsec. I'm Rashmi, and I'm sitting down with Anil today. He is a partner at our firm, Finsec Law Advisors. And today we will be decoding a subject that has been making the headlines the past couple of weeks, Ketan Parekh and front running. So, Anil, just to get the conversation going, um, we are all well aware of Ketan Parekh's involvement in the stock market crash of 2001. You may have also seen the first-hand effects on the economy and the institution at the time. Now, almost 23 years later, and which involved a significant period of debarment from the market, Ketan Parekh seems to have surfaced again. This time with a different kind of fraud, that's front running. SEBI, in an order that was released on Jan 2nd, has also identified several other persons that were connected with Ketan Parekh who have prima facie front run the trades of a overseas big institutional client of two Indian stockbrokers. Now, so can you tell us what your thoughts are about the case at this stage and what is front running all about? Can you explain that to us?
Thank you, Rashmi. I think what Ketan Parekh case, which we are currently dealing with, is a classic case of front running. And front running is a defined, recognized offense under securities law all over the world, including India, of course. So, and the instant case, the allegation is that Ketan Parekh used to front run trades done by a large institutional overseas a foreign portfolio investor. So, in a classic case of front running, what happens is that when a large order is being placed and somebody has the information, prior information that a large order is going to be placed, you take a position prior to that order being placed, therefore taking the price advantage of such large orders. So, if I give you an example, what front running would mean is, let's say, uh, a large order of 100 crores of a particular stock is being an overseas investor wants to buy. So there's a price at rupees 100. So when you are aware of that information that 100 crore order is going to be placed, there's a likelihood that the price of the security will go up even by 1 rupee. So 100 to 101 rupees. So people want to take advantage of that price gain. So what they do is that some person who's aware of the information that a large order is going to be placed, they pass on the information to somebody else, or themselves trade on the market prior to the order being placed by the large institutional investor. So before the 100 crore being order being of a particular stock being placed, somebody will take a position prior to that. They will also buy, let's say 1 crore, 2 crore, whatever amount they can buy. And once the after that, once the order of the big client is being paid, is being put on the stock exchange, of course the stock price, whatever percentage increases, once the stock price increases, these guys sell their stake and thereby make that gain. So this is a classic case of front running. Even in the instant case where Ketan Parekh has been alleged to have run a front running scheme, and the order disgorges almost 65 crores of rupees, which they think is illegitimately gained by Ketan Parekh and its conduit entities. What has been alleged is that there was a one large big client, which is a foreign portfolio investor and a large fund house, offshore based fund house, who used to place orders through two Indian brokers, Nuvama and Motilal Oswal. These two brokers had a tie-up with one person in Singapore national called Mr. Salgaonkar. This Mr. Salgaonkar had some connection with Mr. Parekh, Ketan Parekh. Now, what they used to do is that once, let's say, uh, the big client wanted to purchase a large chunk of a particular stock, this fellow Salgaonkar used to pass on that information to Ketan Parekh, and Ketan Parekh used to take positions in those stocks prior to that large institutional investor placing their order on the exchange. And an interesting bit in this case is that most of these large orders were matched by the position taken by these guys, these large concern clients. So what typical modus operandi would be, let's say 100 crore of stock that particular offshore investor wants to buy. He tells the trader of that offshore investor would inform Salgaonkar, boss, I want to buy 100 crores of stocks. They will say, Salgaonkar used to say, pass on that information to Ketan Parekh, and then Ketan Parekh conduit entity used to take position in that particular stock of more than 100, 110 crores. and once that position they have to buy, and once they have bought, then the institutional investor, when they come to buy on the market, these guys used to sell their stocks to the offshore investors, and the matches order is to match. So apparently in this case 90% of the orders placed by the large institutional traders or the investor who used to match with Ketan Parikh's entities. So this is a very very large scale operation wherein uh, they used to take price advantage of 1.1%, 0.2%, 0.5%, but these were large orders, 100 crores order, 50 crores order. So from that point of view, for a specified period of let's say 2 months, 2 years or something, SEBI has done some large investigation and figured out that almost 40 crores of rupees that these guys have earned, and these are sure shot profits. Then order will get placed, and then you take a position prior to that and square it up when the big client places his order. So it's a very very well organized scheme, and it's actually, and in terms of SEBI laws, it is a fraudulent activity, and because the information that they use to trade is an information which is not in public domain, and the confidential information that a large order being placed, and somebody, Salgaonkar, along with these guys, Ketan Parekh and the conduit entities, had run a scheme towards taking advantage of that information and placing orders in prior to that large order being placed, and thereby taking the price advantage and making so much money.
Thanks for the background on the case, Anil. It's interesting what you said there about how front running as a fraudulent activity is based on selective access to information, right? Now, I understand this is a very frowned upon form of market conduct, and obviously, it makes the markets inherently unfair because certain people have access to information and to the prejudice of a number of other investors. Now, to my mind, there's a very interesting question that has come up. Uh, Now, there is also insider trading, right? Which is also a form of market misconduct that is based on selective access to information. So, what's really the difference between both of these offenses? Which would you see as more severe, in terms of harming market integrity and fairness as such? What's really the difference between the two offenses?
See, insider trading is the news about the company, let's say a particular stock. So you take one particular stock, let's say XYZ Bank. If you have an XYZ Bank, which is, and there's an employee of the XYZ Bank, and the quarterly results are going to come out, and the results are going to be very great, and this employee who is part of the compliance team or the finance team of that XYZ Bank is aware that if this quarterly, once the quarterly results are published, the stock's going to zoom up. So you use that inside information to trade in prior to that information being in public domain. So that is an inside information. This information typically is in relation to some uh, data, information, statistics, or some news or event in relation to a particular company, and that is available to that person because of the relationship with that particular company, be an employer, consultant, or any other manner. So that is very different from front running. Front running is not about the company information. It is basically has to follow a big client. Front running has to, you have to front run a large order. Then large order can only trigger a price change in a stock market which is such large volume and with the large market caps. If we and you buy 10 lakh 5 lakh shares, that's not going to do price movement, so nobody can front run my trades. That's not going to impact anything. But that's why there has to be a big client. There was a big client in this case. There was a large foreign portfolio investor who used to invest like 50, 100,000 crores in India, and the large orders used to place. And that, of course, will have some price impact on the uh, once the orders are placed on the stock market. And therefore, front running is basically, again, information asymmetry, but the information here is about a large order. There cannot be a front running in absence of a large order. That's the difference between front running and insider trading.
Absolutely, that clarifies, obviously clarifies my question here. Another thing that occurred to me while you were explaining the difference is the sheer volumes of the trades of the big client as such, right? So I'd really like to get down to the brass tacks here. Based on past data that we've seen of front running cases in, let's say, the past 4 years, we've seen about 116 cases being taken up by SEBI for front running, and we've seen the number triple every consequent year. Uh, why do you really think that's happening? From 2022 to 2024, the last 2 years, SEBI has disgorged close to 40 to 50 crores towards unjustly obtained gains from front running. So the numbers are really alarming, and especially at a time when the Indian markets, given India's economic growth, the Indian markets need to have a certain kind of integrity to support private investment, to support capital formation. And at this time, any suspicions about market integrity can really harm our economic growth as a country. So, why do you, when given this concerning trend, concerning rise in front running cases, what are your thoughts on some areas in our current structure, our current market structure or systems, that there is some vulnerability for this sort of misconduct to occur? And how do we go about bridging, sort of addressing that concern here? Uh, we've also noticed that about most of these cases have come out of dealer misconduct, so within stockbrokers, like most of the other front running cases we've seen. So what are we missing out on?
See, we have to understand who are the primary players in a front running case. In an insider trading violation, it's the company's information has to be protected. So, of course, there is a policy prescribed by SEBI to ensure that preservation of price sensitive information. There is, of course, a lot of effort put by listed companies to ensure that information which is price sensitive and not available to public at large should be kept confidential and preserved, and only at the appropriate forum at appropriate time should be disclosed to public. But in a front running, it's not the company who controls the information. It's the big client who's controlling the information. And if we see the trend of it, that who are the big clients who places large orders in India or even offshore? Not the retail guys, of course. It has to be institutions. So who are the institutions who put large trades in India? There'll be like FPIs, not all FPIs. Also, there are FPIs who will be large fund houses, maybe mutual funds or otherwise. In Indian, there'll be mutual funds, banks, insurance companies. These are the large institutional traders in India who put large volumes of trades in India. So these are the primary players. One primary player is the big client. The second primary player, this information, who has the information of the trade, is the broker. Is the broker and the big client. Most of the, if you see all the front running cases, either it will be a dealer of the big client will be involved, the institutional investor, or the broker, some employee or some relative of the broker would be involved. So these are the 2 points of where front running happens. So SEBI in the past 2-3 years already, as you've said, more than 100 cases of front running has actually taken place. And it's out of that, how many of cases that we've not been figured out, is there is no data for that, because it's such a it is an only way you can find out is run by algorithm. Now even SEBI, we've read in paper, this case of Ketan Parekh was also found by some algorithm where they figured out that there were trades which are having some patterns vis-a-vis that big client and these 4, 5, 7 individuals, there were patterns. So that is one, is investigative tool, that is more on a what do you do, how do you enforce and ensure post enforcement, how do you enforce if somebody has done wrong, how do you find out and take penal actions. But then how do you prevent it? That's a separate question altogether. For prevention, SEBI has, if you see, recently has passed in August 2024 itself, they came up with guidelines for mutual funds to ensure that the front running do not take place. You have an SOP kind of a thing, put all efforts towards ensuring, internal efforts towards ensuring surveillance mechanism, reporting mechanism, towards ensuring that front running does not happen through AMC, that is big client. But apart from that, there is no regulatory push to ensure that front running does not take place. So as per the data, that research we've done internally, we figured out that mostly 75%, 3/4 of the cases, most times it's the broker's employees who are involved. Here also there was Salgako, who was not an employee of the broker, but there was an MOU with Novama and Motilal, with that broker, with that fellow, to ensure that the trades go through these two entities. So overall, what SEBI has done has not put any emphasis on these large institutional brokers who carry on large trades through of large clients. Uh, in the past 2 3 years, SEBI has made tremendous progress in to protect retail investors through the so like T+0 is one such example. Same day settlement, ensuring that the brokers' funds and the client funds are segregated to ensure the retail guys are protected. But for the institutional guys, who actually, if anybody is losing money in this kind of front running, is that 5 paise, 10 paise, or 1.5% or 2, sorry, 0.5% or 0.25% price loss is by the big client. Not and these guys, SEBI has not taken any steps towards protecting this big clients from this stealing, which is happening rampantly. So my suggestion, as our suggestion, is that SEBI should come up with rules with these large institutional brokers who carry out deals trades for large clients. Now there's no separate rule for institutional broking and retail broking. The same rules apply to them. I think we have to come to a stage where SEBI should come up with some rules to ensure that institutional broking is more formalized manner. They should, I think, couple of things that come to my mind straight away is that you should have rotation of brokers. If you are an institutional client, you should not deal with the same set of brokers all the time. Like you rotate auditors, you can rotate brokers. Then what you could do is that stronger rules for institutional broking, like say a separate dealing room for the institutional broking, separate set of employees for institutional broking, and that also employees should be rotated 2 3 months, 6 months, so that they don't get into a pattern, they don't get used to the system and prevents and to ensure that front running does not happen regularly. So these are the 2 3 steps that you can take. You have to have a focused attention. You cannot just take enforcement action and think that will wish away on its own. Well, SEBI has taken steps towards the mutual fund industry and saying that it's happening through you, but they have not focused their attention on brokers. And if you see most of the cases, at least 75 cases we found, it's the brokers and their employees and relatives were involved in front running. I think that's where the next focus should be, and how to control the large brokers.
That's a very interesting thought, Anil. Definitely, if the trading process for institutional investors to be able to trade in the Indian markets, if they have to compulsorily go through a broker, there's an innate risk in this process of front running. And the only way to really prevent it from happening is by strengthening monitoring and just surveillance tools around dealers of institutional brokers. That obviously is a lot of food for thought for us and the regulator. I also want to focus on the other end of the spectrum, enforcement, right? Now, the fact that SEBI has initiated 116 cases in the past 4 years also speaks to SEBI's improved focus on front running, right? Which is commendable in its very own right. Now, there's a specific tool that SEBI uses in ordinary cases of market misconduct, which is of disgorgement. Now, for the audience's benefit, I'd like to go over the disgorgement tool. So this is now an equitable remedy, and I think the idea of this remedy is to make sure that the wrongdoer isn't unjustly enriched by engaging in market misconduct. So he doesn't get to keep the illicit gains that he's made or the profits he's made out of front running or insider trading. Now, we've seen this tool being employed very commonly. But now we've not seen, while SEBI does disgorge the money which is kept in the Investor Protection and Education Fund, we've not seen this money be given back to the market or given back to the institutional client that has suffered a price disadvantage because of the front run trades. So the money largely is kept in the Investor Protection Fund. As per data, about 40 to 50 crores were disgorged. Only 2.5 or 2.8 crores were used for investor initiatives. So what's happening to the rest of the money? How valid do you think disgorgement is as a remedy if there is no restitution or giving the money back to the investors?
I think that's a very, very fair point. I think before I deal with disgorgement, I think if you should see the numbers of orders they have settled, I think there are 2 3 offenses which are large offenses in a securities law regime, which is, if in Indian Penal Code is the standard, there is murder, there's rape, there's dacoity, there's grievous harm, attempt to murder. These are like 5 6 grievance offense. Then there'll be theft, minor theft, battery, assault, which will be minor offenses. But in securities law, I think insider trading, front running, market manipulation are the three biggest offenses. These are akin to murder, rape, dacoity, etc. Now, SEBI has settled a lot of cases where this front running, insider trading in the past. I don't think fraud too much. Overall fraud they don't settle, but insider trading and at least front running they've settled a lot. So what happens in settlement is that the money goes to the uh, investor protection fund. There's nobody harmed. SEBI has got that money, and they keep the money, and everybody is happy. Nothing happens from there. So, firstly, for enforcement, there has to be some kind of carrot and the stick kind of a thing where you have to. This has to be some deterrence. If let's say I do 100 front running, I get caught in one, I pay only for that one amount, some amount extra, and settle the matter. It then becomes a law of economics. The price of doing something wrong is too low, and the cost of doing something wrong is too low. Then people will commit more wrongs, because there is a SEBI never has penalized anybody. No, have you heard anybody going to jail in India for insider trading, front running? No, because SEBI, as a civil regulator, tries to just get the money out from the system, take the money, and they think their enforcement action is over and they have protected the market. The problem is that if you keep settling the matter, there is no financial incentive for people to from stop doing it. And because right now in the Ketan Parekh case, all they have found is 30 crore. There may be 300 crores separately, also they would not have found out. So to SEBI to say that I will disgorge this much amount and I think if justice has prevailed, I don't think, and that's what happened. Let's say Ketan Parekh again did the same scam again, or not similar, different kind, but a scam again. So point is that when the enforcement is lenient, there you have to understand the menace will never go. How much ever strict laws you make, even if you found guilty of a notice has been issued, you will settle with some amount of money, pay the money. It's like traffic fine. What happens in traffic fine? People keep crossing the red light. 1 out of 10 red lights they get caught. They pay 100 rupees and get out of it, and it's fine. Okay, fine. There's no deterrence for people from stop doing it. So from that point of view, I think from an enforcement, SEBI should stop settling these matters, which are very very grave. I think top three: fraud, manipulation, which is pump and dump, don't and then insider trading and front running. So once you do that, that will give an impression on the market, because if you do something like this, once you get caught, you are over. Not some, it's like a tax liability. I will keep evading tax, keep evading tax. Once some tax liability, I'll pay the money and get out of it. So that is the problem. Even in the securities law, you make it limited to the monetary thing, and also you settle without any charges against you, then there is not even a charge that there is something wrong, you're guilty of something, because settlement are without accepting or denying guilt. So I think that is one big thing SEBI has to look back and reanalyze as to how do we stop this front running. Coming to the disgorgement part of it, as you explained, disgorgement is what? Disgorgement is ensuring that somebody who's made illegitimate gain, should the illegitimate gain is taken out of it. Let's say you made 100 crore, out of the 30 crore, as a Ketan Parekh case, they figured out 65 crore is the illegitimate gain that they have made through these trades. That should be disgorged and given it back. And given it back to who? Given it back to the investor protection fund. Now this investor protection fund, and nobody knows where it is getting used. Maybe some seminars in Dubai or Hong Kong. But problem is that here there is somebody who's been wronged. Is a clear case. Somebody, in this case, let's say an FPI who was investing, who was buying that XYZ shares at 100 rupees. Because of the Ketan Parekh doing transaction prior to that, it become 100 rupees, 10 paise, 20 paise, whatever. That 10, 20 paise is direct loss, which is attributable to this guy. So if SEBI has taken that money and kept it with itself, shouldn't they give it back to these guys? Because you understand there is a difference between SEBI and civil laws. If there is a contractual fraud between you and me, you said that I will do this, and you sign a contract and you don't do it, I can take you to civil court and get some damages from you. But in a securities law, SEBI Act prohibits people to take civil action. The only way somebody who's wrong, let's say in this case, the foreign portfolio investor, they cannot approach an Indian civil court and say that there's so much damage these guys have done by defrauding me, pay me this much money damages. They can't go, because SEBI Act itself says that no civil action can be taken against no offense, which is an offense under the SEBI Act. So what happens then is that this guy cannot take any money, and SEBI does disgorgement and keeps the money with itself, does not give it back to the large trader whose actual loss is there, directly attributable. So that's where we have to understand that SEBI, in a case like this, has to come in a front running case, has to keep restituting people of the loss. If you have said the illegitimate gain, I will take from you, but somebody who's got illegitimately some loss, they've made legitimate loss, illegitimate gain, legitimate loss. So you give the legitimate loss back to these guys who have actually made that loss because it's directly attributable. In Ketan Parekh, this is an interesting case as opposed to other cases also. In other cases, what they used to do, let's say front running, you are a dealer of a broker, and there is a guy, a large institutional or investor who's putting the 1,000 crore order. So you take a small position of 10 lakh rupees, and when that large order comes, price increases 5%, you sell it for 5% higher, you make 50,000 rupees. That is small amount of money they made. These are typical front running which have happened in the past, where with 10 lakh, 20 lakh, 1 crore, people have made that much of money. In this case, it's different. Ketan Parekh case is different because here 90% of the trades put up by this large institutional investor was being matched by Ketan Parekh. It was not like 100 crore order and your order is 10 lakh. If the 100 crore order was put, there were 90 crore was their order. So there's a large scale, everything was getting matched. So it is a directly attributable. I can understand out of 100 crores, if just 10 lakh rupees of order is in place, of course not directly attributable what the price impact is. The price impact is directly attributable in this case. So from that point of view, there is definitely a case should be made out that this money should go back to the people who've lost that the price difference, that the money that if you have calculated 30 crore or 45 crore, whatever the money is that these guys have illegitimately made. So there's a direct case that same amount of money is the legitimate loss of the large institutional investor, which should be protected and given back to them.
I agree, Anil, but wouldn't you also, can we also spend some time thinking about the losses that are not directly attributable to a specific investor? Because as a securities regulator who's tasked with the mandate of protecting investors, public investors, there are a number of faceless public investors who have also suffered losses, right? And market misconduct is an offense of a public nature because it takes away from fairness, it takes away from efficiency of the market. Even if a fair, efficient market is something that is not very, very realistic in the world, it's something we should aspire to. So then, how do we go about uh, giving the money back to these faceless investors who have suffered because the price has been manipulated? There is that it's the price determination process is distorted because of these trades that Ketan Parekh has put in. So how do we do that? So how does this remedy fact sort of how do we fit this into the construct of faceless investors, not whose losses you cannot directly attribute?
See, I think that's where the standard disclaimer, market is subject to risk and you can lose all your money. So in a case where if a stock is manipulated, there is no way that you will get that your money back because of manipulation, because it's like a Herculean task to figure out who made what loss, because the millions of traders keep buying, selling on a daily basis, and during the period of fraud. And overall in the world also this does not happen. But what happens in the West, which does not happen in India, is when there is securities fraud, where the in a case where there is a siphoning of funds, or there's a like a Satyam case, classic example, Satyam case, where there was a fraud manipulation vis-a-vis the books of accounts. The Satyam investors who had their ADR listed in US, got some money through a class action there. But Indian investors did not get anything, because what happens is that there is no structure in India vis-a-vis the class action suit can be exercised, and then some money can be given as compensation to the investors. That system is not there. And one of the reason is because there is no plaintiff litigation in India permissible. Let's say in US, what you can do is, like, if some company has done some fraudulent activity, and lawyer will stand up and say that I will represent the minority investors, and if we get a compensation, you give me 25%. So that's when they can file suit, and there is a deterrence that people will file suit against you to get some class action. Here, there is no incentive for one single shareholder who owns 100 shares to file a class action suit. Nobody will come together as a group, and no lawyer has an incentive to take up that matter, because nobody will give you pay with you fees because you're not getting a percentage of the total settlement amount. So the securities law in India is very skewed because you cannot go to only your police is SEBI, your investigator is SEBI, your adjudicator is SEBI. All three departments, if I have to complain, I have to go to SEBI. SEBI will only investigate and SEBI will only judge. And there is no other second alternative. I cannot go to a civil court to exercise my any kind of violations. I cannot take any money. And if at all any penalty or any violation happens, it goes back to SEBI. So any investor, even from a primary market issuance where there is a fraud, or in a secondary market where the company is not involved and there is a fraud, the problem with Indian investors is that they are left at the mercy of SEBI, and SEBI has never given any money back except for the Sahara kind of refunds, and also so there is no claimant. The money is still stuck in a collective investment scheme kind of a thing. One time they started it, I think Yes Bank IPO case or one of this case where they started cornering of shares. They tried to identify people who had actually lost out. But I don't think SEBI is interested in doing hard work of finding out investors. And actually, to be fair to them, it's quite impossible to say faceless investors. How do you repay if somebody is done front running? And here there is a person who's actually lost. There's a big client who's lost. You can identify that. But somebody is as an insider trading or some, because there is no directly attributable. Even in a kind of fraud or manipulation, if the stock price was pumped up by somebody and it goes back, if some money is come as disgorgement to SEBI, how will it calculate who has lost how much and how will they get it back? And that process will be more expensive than the money that people will collect. So I think that is something, I think even from a world globally, it's not very easy to restitute somebody who's have a loss in the market because of some fraud. But I think front running is slightly different. Front running is directly attributed to one person's loss. So that, I think that can be restituted.
I agree. There are definitely challenges with carrying out 100% effective restitution to all investors. On a, just what I draw from your insights on this entire case is that it's very important to enforce and take action against entities that are front running, because that will act as an effective deterrent in the market. It's interesting because I was recently reading about this rule. That's the 70-25-5 rule. So the 70% market participants want to comply with the law, and the rest 25% will only comply with the law if the 5% which are not are effectively punished by the regulator. So I think that's very directly applicable here, especially in the stage that the economy is in. We really need a very strong and just and fair market to support our growth. On a concluding note, can you now, a lot of our viewers will understand that this is an interim order, and a lot of SEBI's findings are prima facie in nature. And even if a lot of thorough investigation has been undertaken into call data records and IP records, flight tickets have also been analyzed, WhatsApp chats have also been analyzed. So what next? What are the next steps? Is it the final finding against Ketan Parekh, or what can we expect to happen in this case?
I think it's an interim ex parte order, which is by definition not a final, interim by nature. What will happen is people who are charged will have to respond to it. They can also challenge before SAT. And after the interim order, something called a confirmatory order will come. And once that confirmatory order comes, the investigation is still going on. They may add to it any further information that they find, any further allegation. And pursuant to that, once another show cause notice may be issued. It's a long run process.
Potentially may go on.
Yeah, some time because the investigation is still going on. Interim ex parte means the investigation is still going on, but since the offense is so egregious that they have to respond immediately and pass an ex parte order. So I think enforcement wise, I have one more comment before we wrap up for the day. Is if you see what has happened in SEBI's regulatory regime, if you see when they regulate the intermediaries, they have made the rules more expensive for people to start the new business. Net worth requirements, IEAR, mutual funds, do anything large net worth, large amount of people. That net worth regulations have increased and net worth has. But if you see SEBI Act was 1992, 89 it was formulated in 1992. The penalties remain the same. If an offense of SEBI, if you see penalty orders of SEBI, it's got 2 lakh, 5 lakh, 10 lakhs. I think that is no longer a deterrence in Indian market. Then 2 lakh, 5 lakh, 10 lakhs will not deter people. If you want to deter people, you have to impose high penalties. Now, problem with SEBI is that once they tried pushing hard, heavy penalties, their people go and challenge before SET that, see, in the same offense last 2 years back you charged 5 lakhs, now you're charging 50 lakhs, this disproportionate. I think that is why it requires amendment in the SEBI Act itself, rather than SEBI now increasing the ticket size. I think SEBI Act should be amended where the penalty should increase massively. If you see how much penalties SEC imposes and how much we impose, it is, when you have a securities market fraud, you should understand that we only find out 1/10 or 1/20th of fraud what has happens. So from that point of view, the penalty has to be harsh. When the, when there's a theory in law and economics, then when the probability of finding a problem of finding a fraud is very low, that out of 100 cases only one case will be found, the the penalty should be disproportionately be higher, so that the other 99 also don't do it. Because if only 1% out of 100 is being caught and that person is let off loosely, then 99 will have no deterrence to do it. So from that point of view, the penalties have to increase. There is no other way that you can deter. A, you don't take criminal action. B, your penalties are low. C, your enforcement in the case is that only that I am the only person, there is nobody else in this world who can adjudicate our matters upon SEBI. And there's no FIR I can file. I have to go to SEBI and say that this is what they have done. Please take a look into it. EOW takes cognizance only after 100 crores of some fraud, etc. So my point is that entire cases of where if you have SEBI to ensure that this front running insider trading and all is deterred, they're not making cosmetic changes in law. I think their action should speak louder than the language of law that they write. Is more on higher penalties, tougher, no settlement of these small front running insider. You have to make a policy, and if you take these 2 3 4 steps towards and making an example out of people, that if you do something like this, there's a harsh consequences. That's the only way these offenses will go, lesser and lesser number. Otherwise, as we have seen, 3 years it tripled. Another 3 years it may be 10 times. You never know.
Hopefully, it doesn't. We don't. This Ketan Parekh case sets into motion possibly a time when there are higher penalties, more deterrents for something like front running. Hopefully, we don't see another tripling of cases every 5 years for this to happen. On that note, I'd like to wrap up our session. Thanks for sitting down with me, and thank you everybody for listening to us. We'll be back with another exciting topic.
And if you have any comment, please put it in the comment box. And if you want to share with your friends, family, or your colleagues, please feel free, like, subscribe. Thank you.